Chris and I, in the book, talk about legal risk in terms of the interaction between a business's operations and the law. So the law in and of itself doesn't represent a risk. It's only where a business interacts with the law in a way that is potentially wrong that can result in financial or reputational loss. So very important, of course, to articulate the form of loss that you're trying to prevent when you're talking about legal risk. So it is financial or reputational loss. And also very important to understand the behavioural drivers that can result in the risk being realised. And we talk in our definition about a lack of awareness of the law. So you have to know how the law applies to your business, to its products and services. A misunderstanding of the law and how it applies. So you may know which particular pieces of law and regulation apply to your business, but you may misinterpret how to comply with them and therefore cause a compliance error. There may be ambiguity in the law itself, so I suppose that's slightly contradictory when I said that the law in itself isn't a risk, but where there's ambiguity, so it's difficult to understand and you have to make a particular call as to whether to go one way or another, and the law itself changes, that can result in additional levels of risk. And then there's the rogue elements within organisations, the people that don't really worry about how the law applies to them, the reckless indifference to law and regulation, which you would manage through monitoring and compliance. So legal risk is essentially risk that results from misunderstanding, lack of awareness, or reckless indifference to the law and the way it applies to your business.